So court cannot possibly lay down like a parliamentary legislation in what circumstances this can be done. So even a very ordinary case, mistake or a fact, a settlement or a compromise is undone by act. And the court says, yes, there's a miscarriage of justice. My inherent powers will be certainly invoked.
What is the mistake?
So therefore, if that and fraud has been defined so widely, mistake, a mutual mistake, sometimes based on an inducement of an acceptance of fact is a fraud.
But that's not your case.
So
that there is any mistake or fraud.
I'm sorry.
That's not your case.
No. My case is the errors which have gone into or the assumptions of facts relating to who is entitled, how many persons are entitled, and what quantum of compensation. That assumption, which has been noticed by the court in the penultimate paragraph in the May 418 and order, that assumption is proved to be wrong.
If you have entered into a settlement, your view is
that assumption is proved to be wrong.
Assumption entered into by one party.
Yeah.
On a settlement entered into by one party on certain assumptions. If later on, much time later, the party finds those assumptions were not correct, there's a ground to open a settlement.
Increase.
45%.
Yes. No, that's why it's hard to take.
This is why, just think of it, Stanley. This is what the proposition will amount to.
If all my endeavor is
and also under the judgments of the court, what I was required to do, I have not done. But don't tell me that I have not done something which I was required to do. I am a default.
That's what you're also putting to me, whether I'm a default or not. I'll try to come back to it.
If you have done it, you are not a default. If you've not done it, certainly you are majorly a default.
No.
Causing for some embarrassing, in this unit, some embarrassing comments on what you have done or not done in the Union of India.
After giving our anxious consideration to the question we have persevered to hold, that the duty to do justice, the rarest of rare cases, allowed to prevail over the policy of certainty of judgment, although it is essentially the public interest that a final judgment or the final court in the country should not be open to judge. Yet there is circumstances mentioned above wherein declining to reconsider the judgment would be oppressive to judicial conscience and would cause perpetuation of irremediable injustice. That's how it's like a very important way of perceiving how irremediable injustice in a given set of facts is certainly always in the domain of the court. And my only endeavor is to say that look at the totality of the facts, put them all together and see where do we ultimately arrive. There could be a small dark spot here, a gray spot here, and things like that. But the ultimate analysis, if the court were to be told that for this very important reason, in the number of persons, adequacy of compensation, that important reason I say is one of those rarest circumstances with a court visualized to reopen in paragraph 37.
I'm again saying it's the cost of repetition, subject to your verification in the court. If you have not done what that judgment and review ought to be done, why should we not say that you must bear the consequences of it because you are responsible for that situation?
I'd endeavor to see if I can put in a perspective on it. I'll try to see how
I really can't. None of us can find a perspective to it other than either you have done it or you have not done it.
Yeah, and I said
that you'll get it. If you have done it, well and good. No difficulty. Because under those policies also then compensation may have been received. which you were supposed to take, it is possible people may have claimed and received compensation under those policies with passage.
Lords, then go into paragraph
On the
48.
insurance, just a factual thing. The attorney will of course check. The conditions on which the money was transferred to the Reserve Bank, and that's how we assumed this is all being done, said no part of the fund shall be utilized or withdrawn or utilized to meet any administrative expense diverted for any purpose other than payment to or applied to the satisfaction of the victims. The fund may also use insurance premium as scheme of insurance indicated. Not where the question of premium is, there is insurance policy.
Mr. Salve, in a lighter way, yeah, I appreciate your intervention. We can't forget that all this happened because something happened in your factory. You can't forget that.
Not my factory, the Indian factory.
Because at one point of time, it was your factory. Yes.
That's
Yes, sir.
Paragraph 48 at page 59.
Yes. Yes.
So I was just looking at the numbers. The very number of cases which was quoted, looked into from a very ordinary, what we call a
what
service
I was
law
saying.
dispute.
I may just share an anecdote. So Nariman was leading the battle on our side. India's finest civil law lawyers. But, he applied for further and better particular injuries. That's why the government said, so reality, giving names and details of injuries became impossible. That's why the suit was floundering. That's why in para 188, the Lordship said without proof of individual injury, where would the suit have gone is the question. That's why the district judge got frustrated and said, already the meanwhile paid is 400 crores. High Court said 250 crores. That's how the matter was. And your Lordship, as my Lord said, see, I remember that time the Chief Justice, unfortunately, we lost him halfway through the review, Justice Mukherjee. At that time, the first time when it came up, Chief Justice parted. He said, but surely, Union Carbide must take responsibility. Mr. Nariman said, yes, we are willing to pay for this much fee. That's how the whole thing started.
But of course, so Nariman also said the greatest mistake of my life.
He said.
I have placed on record, just by way of digression, I placed on record
It's a social
two
thought.
reports.
Yes.
Two reports.
Whether somebody should defend the party or not. These are many social
I now
ramifications.
practice in another jurisdiction where we are given by the Bar Standards Board. It's a very interesting expression. It's called the cab rank rule. If it is in your area of work, if you are offered a reasonable fee, and if your diary shows you are available, you cannot say no. And there's no question of I don't like this case. So my clerk in London has to keep my diary even if I'm here. So that if an offer comes for brief, he says no, he justifies.
So the change is your diary may have gaps. That was difficult to find here.
I will make an application to Mellon for disclosure. Yeah, I was just trying to say that I placed on record, I'll not trouble Lordship with that, two reports by mass stars working group in US, one showing the difficulties in the reason why settlements are entered into, and sometimes why settlements need a second look. There is some concern there.
Just,
There's a whole range of cases there.
Mr.
And
Tony,
the second also, I'm sorry,
can you just also read paragraph 52?
paragraph
52 at page 30.
52. I'll read a couple of them.
I think your
just
answer would
finish.
be don't have a
I'll read paras 48 onwards so that Lord forbid me to do that. In the cases discussed above, this court reconsider its earlier judgment, inter alia, and the Articles 129 and 142, which confer very wide powers in the court to complete judgment parties. Indicated about the scope of the file before Article 129 and the Code of Record also advert to the extent of power under 142. The upshot of the discussion views that the court to prevent abuse of the process and to cure a gross miscarriage of justice may reconsider judgments in excess of the inherent powers. The next step is specify the requirements to entertain such a curative petition and the inherent power of the court. The floodgates are not open for filing a secondary petition as a matter of course in the guise of a curative petition and the inherent power. It's common ground, except when very strong reasons exist. The court should not entertain an application seeking reconsideration of an order of this court, which has become final dismissal or review petition. Neither advisable nor possible to enumerate all grounds on which such a petition may be entertained, and that's a wise statement of judicial policy. Nevertheless, we think that a petitioner entitled to relief ex debitio justitia establishes violation of the principles of natural justice in that he was not a party to the lease for a judgment adversely affected his interest, or that he was a party to the lease was not served the notice so and so, or where in the proceedings with earned judgment discovered connection so and so, apprehension of bias and judgment adversely affect the petitioner. The petitioner shall the curative petition shall aver specifically that the grounds mentioned in taken the review petition and the regulation will contain clarification, certification of the senior advocate because the fulfillment about judgment.
So,
Here are the view that in the matter is
what is the effect? Of course, you
of the
said
final judgment.
you will come back to it later. What is the effect?
Let me complete reading a few more paragraphs and try.
Our job would have been
How I may fit in. How I may fit in.
our job would have been very simple on the first day and the first 5 minutes. But we thought that looking to the issues involved, we wanted to hear you at greater length. But can we just brush this as a brush aside? This very factum objected to, and though we have committed almost a day and a half hearing that the very jurisdiction of curative is conferred under this judgment. In what circumstances the curative would lie is specified. If that condition is not specified, what happens?
Implicit in the
That is right. This case, 52 has not been observed. 52 is not been. Buddy. 140.
A petition before it was. Because we honestly, we are dealing with a few hundred curative petitions. we also deal with it summarily.
So next step.
There are specialized counsels in the security petitions who sign security petitions.
I can only
Just
read
say but see, it's like none of us are laymen. All of us are governed by law.
absolutely.
All of us have to follow a process of law. Therefore, the process of invoking a jurisdiction requires A, B, C to be done.
52 is not being done.
Has it been done?
You see
Let me
that.
take-
What my brother is pointing out,
Let me-
we didn't want it the threshold because we flagged it the threshold, but we said that okay, you are feeling strongly about some issues as attorney, or we are
I'm grateful
you are
for this.
entitled to this.
I'm grateful for the indulgence.
Entitled to this audience from the court because not only of the office you hold for a number of years, but ultimately we have. I mean, normally a petition on this ground alone, without saying anything more, could have been dismissed. It has been kept in open court because of the issue involved. Therefore, we have.
Lordship, sir.
Please tell us after lunch the two factors. One, did you invoke the insurance? Or two, where is the certificate as required in Pura's?
I'll take the curative petition. It is at page
161.
193,
161.
161,
Petition. 161.
page 161
How does it say
of the curative petition certified by the then Attorney General.
does it say whether a review has been filed as
No.
required?
Now, that aspect I will
Does it
address.
say,
That aspect, whether there is a judgment of your lordships in National Commission of Women in so and so in 2014 for SEC, where the National Commission for Women, who did not file a petition, was permitted to file a curative petition, and because of the importance of the issue involved.
So
it is a precedent and been entertained.
there is otherwise a threshold bar for you. We have still.
That's
I
why
think we have still heard you because I don't think whether any other curative has been argued for a day and a half, but at some stage, all good things have to come to an end. Yes, after lunch.
I will
We'll take it up at about 2:15. I have one special bench at
Very
3 o'clock for 10 minutes.
very well, very. Very.